Thank you, sir, and thank you, Tirupur branch, for giving this opportunity to share some of my learnings with the learned participants. Sir, can you confirm if the screen is visible?
Yes, sir.
I've shared the screen. Is that screen visible?
Yes, sir. Visible, sir.
All right, all right. Thank you. So the discussion that is scheduled today, how I have structured I have roughly, I believe, 1.5 hour time to discuss the nuances of limited liability partnership. And in this 1.5 hour, I'll reserve 15 minutes, maybe towards the end for the question answer. And maybe 1 hour, 15 minutes, I will try to discuss the nuances in detail with regard to various aspects of limited liability partnership. But I don't want to stop you to stop me in between, and you can ask your questions during the session also. It's a closed door meeting, so I won't be disturbed if you are asking questions in between as well. So I'm pretty okay. If you want to raise any points for discussion, then and there itself. During the discussion, I have divided the agenda into almost some 12 basic parts, where I will cover the general discussion on some important terminologies which are used for the limited liability partnership, some of the important aspects which are in general applicable for all limited liability partnership. Then we'll move to the incorporation aspect, the basic aspect of incorporation. I'm not going into the practical difficulties and challenges what the professionals are facing for the last couple of months. I'm sure these difficulties are going to be resolved by the ministry very soon. But yes, they are challenges today. But any principle related issue you want to discuss, you can ask any question that you have in your mind with regard to the LLP agreement, with regard to the constitution, with regard to anything else which is forming part of the limited liability partnership. We will spend out some time on the limited liability partnership agreement also. What is the requirement? What are the content of this agreement? How this agreement is so very important for professionals to understand and draft it meticulously. Often, as the memorandum and article of association is a dejected document and is being drafted in a most casual manner, so we have seen the LLP agreement also being drafted in a most casual manner, usually a copy paste from some of my colleagues or my friends, and we used to ignore the basic requirement of your understanding with regard to that limited liability partnership, leading to unwarranted troubles at a later point of time, which could very well had been avoided had this agreement been thought of at the time of incorporation of this limited liability partnership. We will discuss all that, what can be taken care of and how it can be made more useful for the professionals. Then compliances, which is a very big concern for many of the professionals, that we are burdened with n number of compliances for a body corporate, means company. For limited liability partnership, this compliance burden is significantly reduced because it's a hybrid. It's a hybrid of a partnership firm and a private limited company. So all the advantages what a private limited company is having are incorporated in the limited liability partnership. All the weaknesses, all the disadvantages of the private limited company have been thrown away. Similarly, all the advantages what limited liability, what partnership firm has, are incorporated in the LLP. And disadvantages, the biggest disadvantage being unlimited liability, has been removed from the structure. So that's how the limited liability partnership form becomes a preferred choice for corporates to have such kind of vehicle. Which all type of entities it can be useful, what all compliances are required to be done, that we will understand in detail. Then we also come across a situation where you have a partnership firm. Now your client has reached out to you to convert that partnership firm into a limited liability partnership. How that conversion will take place, what are the ifs and buts which are required to be taken care, that we will understand. Similarly, you are already having a private limited company, but considering the fact that company structure requires lot of compliances to be done, and your management has decided to why not explore a possibility of conversion of that company into LLP. So we'll discuss what all nuances are there for conversion of company to LLP, firm to LLP we have already discussed, and fresh incorporation also. So these are the three modes by which LLP can be incorporated or registered. Now, once you have LLP in place, now your management wants that no, we are now not comfortable with the limited liability partnership structure. We want to move to a company structure. How to convert that limited liability partnership to a company, that also we will understand. So these are three set of conversion, and one incorporation completes the entire round of incorporation and registration. Then many a times foreign nationals are involved, or the foreign peoples are involved, leading to the FDI requirements also. So foreign direct investment compliances, what are applicability, what are the guidance, how these compliances are to be done, all that we will understand. And then last but not the least, regarding the closure of the limited liability partnership. What are the options available? Can we go for strike off, or we have to go for longer route of liquidation or winding up? So what are all options which are available? We'll understand, and we'll understand the process also. And lastly, we will also quickly wrap up the changes what government has recently done starting in February 2022, and maybe the changes which are applicable with effect from April 1, 2022 in the current financial year. And then at last we will have the question answer session. Whatever questions you have in the mind, whatever could not be answered during the monologue discussion, those questions we will take up and understand what are the possible answers to those things. So coming to our first general point, that it is a body corporate. What is a body corporate? We are all students of law, and we understand body corporate means an entity possessing certain peculiarities. The peculiarities could include that it is separate from its members or the contributories, the people who have subscribed. It is different from them. So it is called a body corporate, which is having a separate legal entity status, which has got a perpetual succession. These are all features which are found in the limited liability partnership also. So it is a incorporated entity in terms of the provisions of Limited Liability Partnership Act. And why LLP was introduced in India, if I can give you the very brief background. If you recall, the liberalization in India started way back in 1991. Though a lot of foreign direct investment got attracted to India and we got significant amount of fund flow, but still there was something which was missing whenever we were interacting with the foreign nationals, the business houses, the corporate entities outside India. They were demanding from Indian government that why you don't have a structure called limited liability partnership in India. If there was a structure which is called LLP in India, then we could have invested through that model, because this LLP model has got its own advantages also. With that backdrop, the proposal was circulated, submitted to the government of India. A committee was constituted, and after thorough discussion and taking all the aspects into consideration, the government of India considered to allow the formation of limited liability partnership with lot of reservations, lot of apprehensions in mind that whether it is successful or not, whether it will be foolproof or not. Should not it happen that it leads to some other kind of fraudulent situation? So anytime whenever the government is introducing a new vehicle, obviously the constraints are many, and you have to work in that particular framework only so that the misuse can be avoided. So a limited liability partnership was allowed to be formed with certain limitations. What are those limitations? As we progress, we will see. And many of those limitations continue till date also. Though many changes have been made over a period of time, but still those limitations are still visible in the LLP structure also. Perpetual succession, as we discussed, is a key feature of a body corporate. So we found it in limited liability partnership. Perpetual succession means what? Perpetual succession means it will not die its own death if there are no members, if there are no contributories, if there are no partners. So despite that there are no partners, there is a provision of succession. The other person who will be the legal heirs of the partner, or in the manner what is provided in your LLP agreement, this body corporate will continue to function forever, irrespective whether the partners survive or not. Your existence, rights, liabilities are not affected by the changes in the partner. So that's how distinct from its partner. Your partner is individual, your partner may be body corporate, your partner may be a company or anything else. Natural person or artificial person, both are allowed to be a partner in limited liability partnership. But only the persons who are capable of doing a contract. So minor cannot become a partner. The person who is of unsound mind cannot become partner. These are natural restrictions under the Contract Act, and those restrictions continue for the limited liability partnership also. One more interesting part is the provisions of Indian Partnership Act 1932 does not apply to limited liability partnership. The provisions which are applicable are only and only of a limited liability partnership. Indian Partnership Act 1932 does not apply just because the word uses the partnership. Generally, the limited liability partnership will have the limited liability. However, there is an exception that if you commit any fraud, then your liability becomes unlimited. That is the only exception. Otherwise, your liability is limited. So acts which are carried out by limited liability partnership, or a partner to defraud its creditor or any other person, or for the fraudulent purpose, the liability of limited liability partnership and the partners who have acted with intent to defraud the creditor or for any fraudulent purpose, they shall be unlimited liability for all or any of the debt or other liabilities of the limited liability partnership. So as we discussed and we have understood that liability is limited by default. Unlimited liability is only in case of fraud. Body corporate, as we understand, body corporate means a company which is defined in section 3 of the Companies Act and includes a limited liability partnership which is registered under the LLP Act, LLP incorporated outside India, and a company incorporated outside India. However, it does not include certain entities like a corporation sole, a cooperative society which is registered under any law for the time being in force, or any other body corporate as defined in 1956 Act, or the LLP which the central government may by notification in the official gazette specify in this regard. So who is not body corporate is one corporation sole, cooperative society, or other body corporate, whether company or LLP, which are notified by the central government in this regard. So
Sir,
LLP, yeah, please.
excuse me, sir. The contents are not visible, sir.
Acha, content is not visible.
Yes, it is just a blank screen is displayed.
Okay, let me just try again.
Now it's okay.
Is it coming now?
Yes, sir.
All right. So it will be considered as a body corporate except these three type of structure, that is the corporation sole, cooperative society, or other body corporate, whether company or a limited liability partnership, which is notified by the central government. What is business? Why we are discussing all these terms? Because as we progress in the LLP discussion, these terms are going to be used for the purpose. LLP can do what business? So it includes, it's an inclusive definition. Business includes every trade, every profession, every service, every occupation. I'll tell you one interesting discussion what took place a couple of years back, I think somewhere in 2020. It was COVID time. And Ministry of Corporate Affairs stopped registering limited liability partnership for the purpose of doing a manufacturing business. In the misunderstanding that business includes trade, profession, service, occupation. Because the word manufacturing is not coming specifically in the definition, so the misunderstanding cropped up in the mind of the government and they stopped registering. Then we made a representation to the government, Ministry of Corporate Affairs. They understood the matter and the representation clearly stated that this definition of business is inclusive definition. Inclusive means whatever is provided in the definition part is only illustrative. There could be other characters also which can be included in the particular definition. That's how the inclusive definition is made. And it generally starts with so and so includes. Whereas exclusive definition is business means. So whenever the term means comes, then it is a exclusive definition and nothing further can be added or deleted. Whereas the definition which is inclusive has the possibility to include the other things of the similar character. So we argued that it is very well inherent to consider that business includes manufacturing also. So the including word is paramount, and we have to consider that while interpreting any such terminology in any of the law. Now, financial year is also defined as against the provision of financial year under the Companies Act. There is a bit of deviation. In the Companies Act, your financial year starts from April 1 of one year and closes on 31st March of the next year. Exception is that if you incorporate a company on or after 1st of January of any year, you have a liberty to close your financial year next year, 31st of March. However, if you incorporate a company prior to 1st of January of any year, then it is compulsory to close your financial year on 31st of March of the subsequent year, immediately following year. Now, in case of LLP, the rule is that LLP will have a financial year starting from April 1 and ending on 31st of March. However, exception is that if your LLP is incorporated after 30th of September of any year, then you may end the financial year on 31st of March of subsequent financial year. That is the deviation from the normal law. Your current financial year will end on 31st of March. Let's say we incorporate a LLP on 1st of October 2022. What would be the financial year? Normal financial year is 31st March 2023. Subsequent financial year is 31st March 2024. So if you incorporate a LLP on or after 1st of October 2022, you have a time till 31st of March 2024 to close your financial year. Whereas in the case of company, the timeline starts from 1st of January. If you incorporate a company on or after 1st of January of any year, then you get a time till subsequent financial year, not otherwise. That is one distinct feature. Now, LLP agreement means a written agreement which is between the partners of LLP or which is between the LLP and its partner. What it determines? It determines the mutual rights and duties of partner and their rights and duties in relation to the limited liability partnership. So that's how the LLP agreement has to be understood. So it has to compulsorily define the rights and duties of partner inter se and also the rights and duties of LLP with respect to their partners. Now, what is the requirement with regard to partners? Either individual can be partner, body corporate can be partner. Minimum 2 numbers are required to be there to form a LLP. Now, there is another term which is called designated partner. Who is this designated partner? The designated partner is somewhat very similar to the position of a managing director or whole-time director in a company. The concept is there could be n number of partners in a limited liability partnership. So government with objective to catch hold of some identified people in the event of any default or in the event of requirement of catching a responsibility fixing of any individual, the designated partner concept has been introduced. So naturally, if you want to catch hold of a person, then it has to be a natural person. So only a natural person can become a designated partner. Whereas you can have a body corporate as a partner. Now, somebody will ask a question, if I am having two body corporate companies, ABC Private Limited and PQR Private Limited, they both are joining hand together and they are forming XYZ LLP. Now, partners are ABC Private Limited and PQR Private Limited. Who will be designated partner? Now, ABC Private Limited will nominate one designated partner and PQR Private Limited will nominate one natural person as a designated partner, and these individual natural persons will be considered as a designated partner, because the idea is to fix the responsibility tomorrow if anything goes wrong. So natural persons have only been considered for the purpose of nominated as a designated partner.
Sir, is there any condition that these persons should be directors in the board or managing director?
No, not at all, because we are talking about a limited liability partnership. So a person can be a designated partner in a LLP without having any requirement that these people should be a managing director or whole-time director or a director. I may be not a director or a managing director in any of the private limited or public limited company, but still I can become a designated partner in a LLP. The only requirement for becoming a designated partner is that I have to be a natural person. I understand your question is in respect of body corporate nominee. Let's say ABC Private Limited has given one nominee who is Mr. A, and PQR has also given one nominee who is Mr. P. Now, these P and Mr. A are not required to be director of their respective parent body, ABC Private Limited or PQR Private Limited. They may be director or managing director of ABC or PQR, or may not be also. So even if they are not director or managing director of ABC, the entity which is nominating them as a designated partner, still they can be nominated. They can be their employee, they can be their manager, they can be their any connection will be allowed. I hope that answered your question.
Thank you, sir.
So another condition is that at least one of the designated partner has to be resident in India. Now, condition of residency is coming again. You have to stay for minimum number of days in India to qualify as a resident in India. You will be required to obtain a designated partner identification number, which is nothing but a director identification number. Now, DPIN and DIN both are synonym. Earlier, when the concept was introduced, the DPIN number was allotted separately and DIN was allotted separately. But now there is no longer a concept. Both concepts have been merged and only one DIN number is there. If you have a DIN number, you need not have a separate DPIN. Now, appointment of designated partner is required to be intimated to the registrar within 30 days of his or her appointment. Responsibility and liability. So the designated partner is responsible for doing all the acts, matters and things which are required to be done by the limited liability partnership regarding the compliances of law, filing of document, return, statement, reports, whatever is specified in the LLP law. So whatever compliances are required under the LLP law are the responsibility of the designated partner. If they fail to comply, they are liable to the penalties which are going to be imposed on LLP for any of those contraventions. Mind you, partners are per se not liable. That is another advantage of having a designated partner and a LLP structure where you can define as to who are the people who are designated for compliances, and the people who are simply partner, they will not be liable for any of the actions or defaults whatever the LLP has committed. There are certain disqualifications also in becoming a partner, designated partner, like the person should not have been adjudged as insolvent during the preceding period of 5 years at the time of becoming a designated partner. He should not have suspended payment to his creditor and who has not made any composition with them within preceding 5 financial years. Now, this is a very onerous responsibility. I will take you to the provisions of section 196(3) of the Companies Act 2013, which also has a similar provision for a managing director, which says that a person who is suspending his payment to the creditor or who has made any composition within 5 years, then he will not be eligible to become a managing director. So similar provision has been incorporated for a designated partner also, as I mentioned, because the responsibility and liability is somewhat similar to a managing director. Then you should not be convicted by court for any offense which is involving a moral turpitude. So offenses which are moral turpitude offenses are separate. How you will distinguish? Moral turpitude means somewhat which is related to morality. If I just commit an offense and I am sentenced to imprisonment for, let's say, 6 months. So if the offense is not involving any offense of moral turpitude, then I may not be, if I have done a simplicity or a non-compliance, which is not a offense which is involving a moral turpitude, I may not be debarred. I'll be debarred only when my both conditions are fulfilled, that I am involved into the offense which is relating to the moral turpitude and I have been sentenced to imprisonment not less than 6 months' time, then I'll be disqualified. Or if I have been convicted by court for any offense under section 30 of the LLP Act. Now, you should ask one question. Now, government is doing a lot of decriminalization in the Companies Act. And a lot of provisions have been decriminalized in the LLP law also on a similar line. Can anyone tell what is the advantage of this decriminalization? Any thought on that? Any bigger tangible advantage that we can have? Answer is yes, because the government is doing a decriminalization now, and decriminalization will lead to a situation where I will be imposed with only penalty, not with fine. That means criminality will not be involved. So it will not be categorized as a conviction. I can be convicted for offense which is criminal in nature. The offense which is civil in nature, I don't get conviction. My offense is adjudicated. I'll spend some more time little later on this particular point as to what is civil, what is criminal. But for now, we just understand that if you are adjudged as insolvent, you cannot be appointed as designated partner. If you have suspended your payment with creditor, you are not eligible. If you have made any composition with them, composition means compromise, settlement with them, in the past 5 years, you cannot be appointed. If I am being convicted for offense involving moral turpitude, I cannot be appointed. And sentenced to imprisonment, I cannot be appointed. Or if I have been convicted for any of the offense under section 30 of the LLP Act, I cannot be appointed as a designated partner. Whenever you are making any changes in the designated partner, you are required to appoint a designated partner within 30 days of vacancy. And if you don't appoint, then there will be one DP. Each partner shall be deemed to be the designated partner. So if there were two, you have not appointed one on resignation, all the partners will be considered as designated partner. This is a fallback clause. Means what if you don't appoint? Non-compliance will happen, that is on one part, but all the partners will be considered as designated person for the purpose of responsibility and duty. If you have to compare a designated partner vis-a-vis a director. So designated partner, you are required to have minimum 2. Similarly, in case of director, either 2 or 3. If you are a public limited, then 3, otherwise 2 is required to be maintained all the time. Only individual can be appointed as a designated partner. Similarly, individual can be only appointed as a director also. There is a requirement to have at least one director as a resident in India. Similarly, there is a requirement to have one resident designated partner who shall be resident in India. Now, directors can be a non-shareholder also. Though in case of a LLP, there is no concept of shareholding. There is a concept of contribution or partnership share. So, but in case of LLP, only partners can be eligible to become the designated partner. So, this is a position which is different from a company where to become a director, I need not become a member. Unless your company is having a requirement of a qualification share, which is also not legally not mandatory in any of the cases. But in case of partner, LLP, your partner can become, only your partner can become a designated partner. So he has to first become a partner, then amongst the partner only somebody will be elected as a designated partner. Prior consent is required in both cases. DIN is required to be obtained in both the cases. Now, director is certainly an officer in default. Now, there is no concept of officer in default per se under the LLP law, but still the law is very clear that designated partners shall be liable for all the penalties which are imposed on LLP for the contravention. So this is a brief background what I thought of to discuss with regard to the general provisions of the limited liability partnership. Now let us move to the incorporation, which is very simple process. Incorporation can be by way of 3 modes. Either it can be a fresh incorporation, or it can be a conversion of partnership form into LLP, or it can be a conversion of company to LLP. So these are 3 modes by which we become LLP. There is one mode by which we will convert LLP into a company also. What are the documents required for the purpose of incorporation? You require a name by which your LLP will be known, and your name must end with the limited liability partnership or LLP as you like. Your proposed business, what you want to do, registered office address, name and address of partners, name and address of designated partner, and such other information as may be prescribed. So incorporation of LLP is quite an easy task though, but there can be technical bottleneck, there can be technical challenges. So as I discussed earlier in the beginning of session, if you have any doubts with regard to the procedural aspect, fundamental aspect, principal issues, those you can park or you can unmute and we can discuss. Otherwise, the process of incorporation of LLP is quite a simple. You just need to collect and collate all the statutory document with regard to the designated partners, their registered office address, their address proof of registered office address, and you have to file a form in a particular form with the Ministry of Corporate Affairs online. Fees is paid online, and now the web-based form concept has been introduced. So you have to fill everything on the electronic platform itself, and after that a PDF will be generated. You will affix your and professional's digital signature, and the form will be submitted in the normal route as the other filings are done. And after that, the ROC will approve your LLP and the LLP will be incorporated. Now, what is effect of registration? Effect of registration is that,
Excuse me, sir.
yeah, please.
The PAN number of the LLP is in the same format of a partnership firm, sir.
Yes.
Yeah. When a firm is converted into LLP, whether we have to use the old PAN number of the firm or a new PAN number will be given to the LLP, sir.
So a good question. It will be a new PAN number which will be allotted to a partnership, to a LLP. Same PAN number will not be continued. Now, that question I have answered separately also. While
Yes, thank you.
we'll be discussing the conversion of partnership form into LLP. Your question is valid that this also has a same character, but internal mapping is different. Internally, it is mapped as a partnership form only. So when you convert to LLP, you need to obtain a fresh, though it is a continuance of the existing partnership form only. Now, for all practical and legal purposes, but as far as the permanent account number, income tax department, and the other departments are concerned, it is considered to be obtaining a fresh registration for your PAN number. You have to surrender with the request that old partnership form has been converted into a LLP, and this has to be taken on record with them, and then the new PAN number is generated. Now, what is the effect of incorporation or registration? You can sue in your own name, or you can be sued in your own name. That is XYZ LLP. You can acquire, hold, and develop or dispose of any of the property. You'll have a common seal. You can do and suffer such other act and things as the body corporate may lawfully do or suffer. Whether pre-incorporation contracts are required to be ratified by all partners, that is the question that I'm parking. We will discuss it towards the end of the session. Meanwhile, just keep thinking over it as to whether pre-incorporation contracts are required to be ratified by all partners, or maybe the designated partner itself can ratify them. So if I can lay down the requirement under the incorporation, for the purpose of business of LLP, the partners are considered to be an agent of limited liability partnership, but they are not agent of other partners. So there are two partners, X and Y. X is not acting as an agent of Y, but both X and Y are considered to be an agent of XYZ LLP. That is one point. Who is eligible to become partner? Section 22 gives you the answer. Either by becoming a subscriber to LLP or the incorporation document, you become a partner. Or LLP agreement itself will be providing you the means and mode by which you can become a partner. Relationship of partners are given in section 23, and the rights and duties of partner with other partner and with the LLP are governed by the agreement. Whatever you write in the agreement, subject to provisions of law, that will be binding. If you don't enter into any agreement, so whatever principles are set out in first schedule to the LLP Act will become automatically applicable. Now, cessation of partnership interest, section 24 deals with the same. It will be always be in accordance with the LLP agreement. If you don't have any agreement, then resignation notice in writing will be required for the 30 days. On the death or dissolution, also a partner can cease, or if the partner has become unsound mind or insolvent declared by the court of law. How the changes in partner take place? Partners become or cease to be partner has to file a notice in writing with the registrar within 30 days. Any change in the name or address of the partner is required to be intimated to the LLP and to the registrar within 30 days of such change. LLP has to file Form 4 and Form 5 is required to be certified by a chartered accountant, company secretary, cost accountant in practice. Process is very simple. You will go for reservation of name as a step 1. Application, which is now web-based, is required to be submitted online, similar to what we are doing so far in the case of a company incorporation. A similar run LLP module will get opened. You can go there, put certain inputs of data, and you will be registered as a name approved. Application for incorporation can be made in LLP web form, that is Philip. In web form 9, which is an integrated service for incorporation of LLP. So after you submit your name reservation, your company incorporation or LLP incorporation will take place by filing web form 9. Registrar will issue the certificate of incorporation, which will be in form 16. And within 30 days of incorporation of LLP, the LLP agreement has to be executed and filed in web form 3. This is the most important provision and most ignored provision also. Many of the professionals have not filed this web form 3 in the misunderstanding that I have incorporated LLP, I have got the certificate of incorporation, my job is done, I need not do anything further with regard to the filing of any LLP agreement. But mind you, LLP incorporation is just one part. LLP agreement is also required to be executed and filed within 30 days of issue of certificate of incorporation. So after you submit your Philip form, the person is required to submit the consent of designated partner in the linked web form 9. If you have already obtained your DIN number, then you have to attach form 9 as an attachment. That is the only difference. If you have already obtained the DIN, then you have only to, a web form will come and you have to just sign that web form. If it is not, then you have to attach Philip 9, IN's form 9 as an attachment. That is the only difference between the two processes. Contribution can come either in cash, it can come in kind also, it can come in by way of a tangible property, it can come by way of intangible property. So your LLP provides you a lot of flexibility. Let's say we are 3 partners. I am having a capital. I am saying that I can bring the money The other partner is having a immovable property, he can bring his immovable property. The other partner has got some goodwill or intellectual property. So he can bring in some intellectual property and he can have the contribution after doing the valuation of respective assets. Or also it provides contract of service. I can take some percentage of share after doing the valuation that I will continue to provide the service to the LLP for the next maybe 2 years, 3 years, 5 years, whatever is the contract of service. That can also be the mode of contribution. Now, what are the compliances which are applicable on the LLP? In routine compliance, if I can say so, there is an annual return which is called Form 11. Form 11 is nothing but a summary of partners of LLP and an indication whether there is any change in the management or not. That is the content. PCS is required to certify if the annual turnover crosses 5 crore or capital crosses 50 lakh. When you have to file? You have to file within 60 days from the close of respective financial year. There are event-based compliances. Whenever there is a vacancy in designated partner, you have to fill the vacancy within 30 days. And if you are not filling, all the partners will become DP. Changes in DP, you will be filing another Form 4. The person becomes or ceases to be partner, you have to file Form 4. Change of name, you will be required to file Form 5. You will be doing a process, name reservation, you will file Form 5 and a fresh certificate of incorporation will be generated. After that, within 30 days, you have to file a supplementary agreement in the Form 3 within the period of 30 days. Further event-based compliances which are required to be done, like if you are shifting your registered office within the state under the jurisdiction of same ROC. So whatever is specified in your LLP agreement, you have to follow the same. So your LLP agreement becomes a binding document on you and you have to ensure that you have done all the necessary compliances. Consent of all partner is required if agreement is silent. So you have to take care that you have provided something, otherwise all partners' consent will be required. Execution of supplementary agreement will be required if you are changing the registered office within the same state, within the jurisdiction of same ROC. Only thing that is required is to be done is Form 15 has to be filed within 30 days of shifting and then file Form 3. Now, if you are changing your registered office within the state under the different ROC, again here also you have to follow the process what your agreement says. If your agreement is silent, consent is required of all partner. Supplementary agreement is required to be executed here also. Form 15 and Form 3 are required to be submitted. Now, if you are shifting the registered office outside the state, whatever you have written in the agreement that you have to follow. If you have not written, then consent of all will be required. So be mindful that your LLP agreement is going to decide as to what action you are required to take on each of the corporate action. Consent of secured creditor. In previous 2 occasions, there was no consent of secured creditor, but if you are moving from one state to other state, secured creditor consent is required. Supplementary agreement we are required to prepare in all cases. So is here also. Then you are required to publish a general notice of change in the newspaper, where you will publish English daily newspaper in a principal language of the district at least 21 days before filing of Form 50. Then you have to file a notice of change in the registered office in Form 15 within 30 days. Form 3, supplementary agreement. And then once the form is approved, whatever letterhead, whatever document, whatever signboards you have to incorporate the changes in all such documents also. Now we move to the LLP agreement. By now you must have got gathered how important is the LLP agreement. Lot of R&D has been done in respect of LLP agreement so far in the past, maybe from 2008 to 2022. Lot of research has been done in last 14 years, but still lot more needs to be done. Roughly about 1 lakh LLPs are in existence, but still it has a huge potential to convert the unstructured business into a structured model. And the LLP models, LLP agreement models will evolve to overcome the challenges. I'll give you a couple of examples. What if suppose you are incorporating a LLP, let's say with 10 partners, and tomorrow these number of partners are going to be increased to, let's say, 200. And every month you are adding one partner. What will happen? You will be amending the LLP agreement almost 200 times in the entire period of couple of years, because you have to modify the agreement every time whenever you are making any changes. Can we do something in LLP agreement? Shifting of registered office, change of name, change of business, bank account, decision-making process, day-to-day management. So all these areas we are required to bring very clearly as to what process is required to be followed. You can get many drafts online, offline. You have to see as to what you want, what suits to you is most important, instead of what is written in the standard document. In any case, you cannot flout the provisions of law. Wherever LLP agreement is required to have certain clauses, then you will be incorporating. You cannot agree something in violation to the law in the LLP agreement. What is not allowed in the LLP agreement, what is not allowed in the law, you cannot incorporate in the LLP agreement also. That is the thumb rule. So you have to see as to what suits to your requirement to decide what will be included in the LLP agreement, what will not be included, and how it has to be included. Most common dispute is in case of death, in case of cessation of partner. Why can't we write a simple English language to decide as to how the cessation of partner will take place? Whether legal heirs will have a right to claim their nomination in the LLP, or if we want to stop, then what are the ways and means by which we will be able to stop? Whether LLP will be paying interest on yearly basis on the unsecured loan that the person contributes, or the partner's contribution, or it will keep on accumulating. There are n number of things which are required to be discussed and deliberated. So for each and every clause, typical LLP agreement will be having some 50-60 odd clauses. What you need to do is you need to analyze as to what clause suits to your requirement, and based on that you modify. Then see the law that it does not violate the provisions of law. Your agreement should not be repugnant to the provisions of law, because if it happens, then to that extent your LLP agreement will become null and void, or your provisions of law will become binding. So it has to be filed within 30 days. We agreed. This is a most common mistake that the professionals are doing. That also understood. Whenever you are doing any alteration, your alteration also is required to be submitted within 30 days. Form is LLP Form 3, in which you have to submit this document. Now, assignment and transfer of partner's right can both be separately assigned, is a question that I am posing to you. Now, rights of a partner with respect to just give me a minute. Just give me a minute. Hello.
Ramu sir, I'm not getting his slide. Is it for you also? Sir, we are not getting
Sorry.
your slides. Sir.
Yeah, please. Somebody is saying something.
Sir, we are not getting your slides, sir.
Actually, you are not able to see the slides.
Yeah, the slides are not moving actually.
Is it coming now?
Not yet, no, sir. So, Ramu sir, are you getting it? Now I'm getting, sir. Okay.
Now it is coming.
Yeah, it's coming.
All right. All right. So we were on LLP agreement only as to what are the rights of a partner. To the rights, one of the fundamental right is that in case of like partnership firm, they have a right to share the profit and losses. So here also they have a right to share the profit and losses. They have right to receive the distributions in accordance with the LLP agreement whenever there is a transfer of stake or it is sale of the stake. And such a transfer does not cause disassociation of a partner. It cannot be regarded as dissolution and winding up of LLP. And such transfer does not by itself entitle the transferee or assignee participate in the management or conduct of activities. It is by agreement that whether the person will get that right or not. Just because I have acquired the rights of a other partner, that does not mean that I will get a participation in the management and conduct of activities also. So management and conduct of activities is by way of a separate provision. Specific provision has to be there. So whenever we are drafting such supplementary deed, we have to be specific. Now LLP Act allows the transfer or assignment of economic rights without changing the management of LLP. So it is possible that rights are transferred or assigned and transferee does not automatically become a partner. Now we come to incorporation part. We have seen by and large. Now, if we have a partnership firm and we want to convert a partnership firm into a LLP, it will be a case of a registration of partnership firm to a LLP. What advantage you get? You get the advantage of limited liability. You get the advantage of survival. You get the advantage to make unlimited number of partners. There is no restriction. Transfer of ownership become much more easier. In case of partnership firm, FDI is not allowed. But if it is a LLP, FDI is allowed. So higher credit worthiness of the partnership firm, LLP, is there in comparison to a partnership firm. Now, conversion will take place as per section 55 of the LLP Act. The registration of partnership firm is optional and not compulsory under the Indian Partnership Act. So can we say that even unregistered firms are eligible to opt for conversion? So when we convert a firm into LLP, the LLP which is formed from the partnership firm must have same partner as there are in the original partnership. The LLP which is formed cannot have new or less number of partners than the partnership firm. So it will be a replica of partnership firm only. Therefore, if any partners are to be added to LLP, first we have to convert that partnership firm into LLP. Then LLP may be added with some more partner or deleted the number of partners. Consent from all partners is required. That is the condition number 1. Minimum 2 number of designated partners are required to be there. At least one will be resident in India. And you have to have up-to-date filing of your income tax returns. The process of forming a LLP from a partnership firm is more or less same. We file application for reservation of name through Run LLP. We file web form Philip 9 and we file form 9 or web form 9 as a attachment towards the consent. If you have DIN number, your web form 9 will go, otherwise a physical form 9 will go. Additional document is LLP form 17. So this is a new form which is required to be submitted if you are converting a partnership firm into LLP, and there are lot of things which are required to be attached with that LLP 17. There has to be a statement of consent of all partners, list of unsecured creditor along with their consent for conversion, statement of asset and liability of company which is duly certified by a chartered accountant, then approval from any other body authority as may be required, that is also required to be there. Then declaration for part B of form 17 by the designated partner. In the prescribed form they will give the declaration, and the income tax return latest copy acknowledgement is also required to be attached. So these are additional requirements. Form 17 along with the attachment is an additional requirement to convert your partnership firm into LLP. Registrar will issue a certificate of incorporation, and within 30 days you are required to file a LLP agreement. Effect of registration, your LLP will come into existence. Your partnership firm will be deemed to be dissolved. And if it is earlier registered under the Indian Partnership Act, it will be removed from the records of the respective registrar of firm also. All tangible, intangible assets, liabilities, rights, privileges, obligation of a partnership firm will become a liability, asset, right, privilege, obligation of a limited liability partnership. All the legal cases which are pending by or against the partnership firm will continue in the name of a LLP. Any order, any judgment which is in favor or against will be enforced against the LLP. All your contract agreement which were up till now in the name of a firm will become a agreement or contract enforceable against the limited liability partnership also. Now, liabilities we understand a bit more. What is the liability of a partner? For the liabilities and obligations of firm before conversion. So it says that every partner of a firm that has converted into LLP shall continue to be personally liable. This liability is joint and severe for the liabilities and obligations of a firm which were incurred prior to conversion or which arose from any contract entered into prior to conversion. So, if you are converting your partnership firm, the liabilities which are up to the date of conversion, whatever has been taken over as a liability in your books will definitely be part of the LLP, but whatever has not been taken over will continue to be there as a personal liability of the partner. So if somebody is converting it with the presumption that all liabilities will now be vanishing, so that is not the case. If any such partner discharges any liability or obligation, he shall be entitled to be indemnified by the LLP in respect of such liability or obligation. So that is the only silver lining or only motivation for a partnership firm when it is getting converted into LLP, that a partner can be assured that he will not be personally liable, and even if he is going to be personally liable, he is going to claim a compensation from the LLP also, indemnification. And notice of conversion will be required to be made in all the official communication. So up to 12 months, which will commence not later than 14 days after the date of registration, the name of new LLP along with the statement that will contain the date of registration, fact regarding the conversion of partnership firm into LLP, and name and registration number. So generally we are writing formally, so and so firm name registered under the Indian Partnership Act 1932 with registration number so and duly converted into LLP under second schedule of LLP Act so and so. If you do any default, then there is a severe punishment for the same also. Now we come to another third aspect, that is conversion of company to LLP. Here also you require a consent of all members. Only members can become partner. Consent of creditor is also required, and there is no security interest in the asset which is subsisting or in force at the time of application. That is the additional requirement that we have to see. Here also your routine standard incorporation format will follow. Name reservation, Philip 9, and instead of LLP form 17 in case of partnership firm, here you are required to fill LLP 18. And LLP 18 also has got certain attachment. Here also you are required to attach consent of all members, unsecured creditor, then asset and liability, permission, and income tax acknowledgement. Certificate of incorporation will be issued within 30 days. You have to file the agreement. Same effect of registration as is in case of a partnership firm. The company case also, the effect is same. All the asset liability become the liability asset of a LLP. The company is deemed to be dissolved and removed from the record. Pending proceeding continue against the LLP. Order is enforceable against the LLP. Contract arrangement becomes enforceable against the LLP also. Similarly, here also you have to do the communication in your all your communication regarding that formally so-and-so company registered under the Companies Act 1956-2013 with SIN number so-and-so duly converted into LLP under the third schedule of LLP Act 2008 with effect from so-and-so. Now this fact is required to be continued to be mentioned for next 12 months. Now we come to the last limb, that is conversion of LLP to a company. Now you are incorporated into a LLP and now you want to convert your LLP into a company. You have to ensure that secured creditor have either consented to or given their no objection to the conversion. That is point number 1. You have to pass a resolution for conversion. You have to publish the advertisement in the newspaper in form URC2. Newspaper advertisement will be in the vernacular language, will be circulating in the district of registered office and in English, seeking objections, if any, within 21 days from the date of publication. You have to serve the copy of this publication to the registrar of LLP along with the advertisement published in the newspaper, and you have to preserve the proof of sending also. Documents what are required is a list of partner showing their name, address, occupation, details of shares which are proposed to be allotted, not being more than 6 clear days before the date of seeking the registration. List of member in the new company along with details of shares which are allotted, LLP agreement, supplementary deeds, then copy of certificate of registration duly certified by the 2 designated partners of LLP. No NOC is issued by registrar of LLP and a clarification letter can be attached. In certain cases, this difficulty is coming. So that clarification we have given, if an NOC is not coming from the registrar because the registrar happens to be the same. So and clarification letter can be attached. A declaration from the directors regarding the content of document is required to be given. Consent of directors is required to be obtained. Declaration from first director, written consent from the secured creditor, then statement of asset and liability, which is required to be certified by the practicing chartered accountant. Income tax return, the advertisement copy sending to the ROC, the declaration that you will pay the stamp duty, statement of proceedings which are by and against the company, affidavit provided by the members that upon registration, an intimation shall be given to the registrar within 15 days for dissolution, and newspaper advertisement along with the acknowledgement copy serving the notice to the registrar, LLP and CRC. So these are all documents which are required. Then there would be additional document with regard to a PCS certificate regarding the payment of appropriate stamp duty. Then conversion consent of member, provisional balance sheet, then consent from DIR 2, DIR 8, MBP 1, and then declaration that required documents are filed with the registrar of LLP. First director details are required to be provided. Process is same. You have to file a SPICE web-based form. Name reservation, you will go select part 1. You have to select LLP to company. Don't select a new incorporation. Then you will be selecting new company others. Then it will lead to allow you non-acceptance by system. If you select this option, new company others, Now then URC one will not be allowed. Then you will struggle and your company fresh will be incorporated, but it will not be a conversion of LLP. If you want LLP conversion, you have to select part 1 specifically, which is LLP to company. Now MOA will differ slightly because it will be required to incorporate the details of the partnership deed also. For conversion of LLP to company, table F is not applicable, but you have converted your LLP to a company, then later on you can modify and table F can be made applicable. The after incorporation INC 20 is also required to be filed. In INC 20A, you have to provide a clarification that because this is a case of conversion, money has already been received at the time of formation of LLP and LLP is already into business. Provisional balance sheet of LLP is required to be attached. This is how your conversion of LLP into company takes place. Very briefly, I'll take another 2 minutes to briefly tell you about the provisions of FDI. The restricted category is the citizen of Pakistan, Bangladesh, or the entities in Pakistan, Bangladesh, FPI, FII, FPCI. These are restricted category. So LLP Act allows the foreign national and foreign LLPs to become a partner in LLP, number 1. Number 2, ease of doing business India policy. The FDI approval is now permitted same way as is permitted for the companies. A person who is resident outside India or entity which is incorporated outside India may invest either by way of capital contribution or by way of acquisition or transfer of profit shares in the capital structure of LLP. Mode of payment by the foreign direct investment will be through capital contribution by way of inward remittance through banking channel or by the debit to NRE or FCNRB account, which is maintained with the AD bank. Downstream investment, there would be certain restrictions as we are having in the case of a company, but it shall be permitted to make downstream investment which are engaged in sectors in which 100% FDI is allowed. Reporting is disclosure in your board report and disclosure in like single master form, form DI, form LLP 1. All these disclosures, as in the case of a company, are required to be made. I'll just take a minute more to discuss about the closure. So as there is a provision for striking off of a name of a company from the registrar of companies record, that is the section 248. Similar provision exists for the LLP also. If your LLP does not have any liabilities or debt to pay, you can, by taking a unanimous decision, close down the LLP by striking off. Or if your LLP has not started any business, you can close. Or if in last 24 months you have not done any business with the consent of all partners, you can close. One question which is frequently asked, that I had incorporated a LLP in 2010 and in last 12 years we have not done any business. Are we required to file my previous balance sheet? Because per day 50 rupees fine is required to be paid. So a huge cost will be there. So for benefit of all the professional, let's be very clear. You are required to file your financial statement only for the period during which you have done business. If you say that you have not done any business at all, you are not required to file. Let's say you have done business till 2012. So for 2 years you are required to file. After that you are not required to file. The strike off precondition is no liabilities or debts to pay. You have filed form, this is what we discussed, and consent is required to be there. You have to close all your existing bank account. Application is required to be submitted in a prescribed form with a consent, with a statement of nil asset and liability from a chartered accountant, which is not older than 30 days at the time of filing in Form 24. Affidavit will be coming from all the designated partner. Indemnity bond will come from all the partner. Latest income tax return, whatever you have filed, will be required to be submitted. And copy of initial limited liability partnership agreement. If you have not filed at that point of time, you have to file that also at the time of closure. Processes: MCA will review the application, will make a publication in the official gazette on the website of MCA, and after expiry of period of 1 month, the registrar will strike off the name from the list of LLPs maintained in the registrar office. Another mode of closure is a liquidation. Now, with advent of insolvency and bankruptcy code, you cannot wind up any body corporate except after compulsorily a insolvency resolution process for 180 days has been processed. So only one option is that when LLP is solvent, then you will be allowed to go for voluntary liquidation under section 59. So it is different from compulsory liquidation. Compulsory liquidation is some other person or your partner themselves are submitting themselves before the adjudicating authority for resolution. And if resolution does not happen, then the closure will happen. Other option is that if you want to voluntarily close, then section 59 can be invoked, and 59 can be invoked only in cases where you have a solvency. Solvency means your assets are more than liabilities. You are in a position to repay all your liabilities what the body corporate is having. Very quickly, in a minute, I'll just explain some of the recent changes also, what are effective from 1st of April 2022. Like some of the provisions of Companies Act have been made applicable on the LLP also. Like significant beneficial owner, the requirement what was made in the Companies Act in terms of FATF guidelines are now made applicable for the LLP also. Or qualification, disqualification regarding appointment of a director under the Companies Act will now become applicable on the LLP partner also. Regarding vacation of office of director will become applicable on partner also. Maximum number of directorship provision will be applicable on the partner also. Inspection inquiry under section 206, 207 is applicable on the LLP also. Appeal against strike off, that is section 252, is now applicable on a LLP also. There will be certain offenses will be non-cognizable as per the provisions of section 439. Now then they have brought the concept of small LLP. If your capital is 25 lakh to 5 crore, turnover is 40 lakh to 50 crore, you'll be classified as a small LLP. So there will be certain advantages that will be reduced fees, reduced penalties, reduced compliances as is in the case of a company. Startup LLP will be recognized separately with lot of advantages. Change in criteria of resident designated partner is made. Accounting standard will become applicable. Compounding of offenses provision 441 will become applicable. Because the offenses are criminal in nature, the provisions of special court will become applicable to the LLP also. Lot of offenses have been decriminalized. Under the 1956 law, all the offenses were criminal. Later on, the offenses were decriminalized under the 2013 law, and later on under the ease of doing business policy, lot of criminal offenses have been decriminalized. So the distinction is that for criminal offense, the conviction can take place only after trial by the special court. Whereas if an offense is civil offense, then the trial can take place before the adjudicating authority, who is nothing but a registrar of company. So government wants to push more and more offense towards the civil offense so that the registrar can quickly levy a penalty and the appeal can be filed to regional director if you are not satisfied. So adjudication of penalties is the in thing and is the crux of matter what the changes are talking about. I think I'll pause over here and I'll wait for the queries what people may have. So the moderators can facilitate the unmuting by the participants and they can ask the questions. Please.
Sir, excellent presentation, sir. Only one small doubt.
Your voice is very, very low. Can you be a little louder?
Oh, why not, sir? Sir, in case of if you suppose if the LLP wants to extend its business or change its business, any formality to be adopted?
Yes, it is possible. You can change the objects of LLP, no problem. Whatever process you have mentioned in your LLP agreement, you have to follow that. Otherwise, consent of all partners required.
And that has to be filed with the registrar also.
You will be required to file with the registrar, correct. Form 3 supplementary deed will be required to be submitted.
And as in the case of partnership, there is no question of removal of partner in LLP also.
There will be no
question of removal of partners in LLP. Because in
removal of partners can be done if it is provided in the LLP agreement. So LLP agreement is a beautiful piece of document. If it is provided in the LLP agreement itself as to in circumstances in which the partner can be expelled, like if he is doing a competing business, right? So there can be certain circumstances which can be provided and the partner can be expelled also. But that has to be explained clearly in the partnership deed. Possible.
Okay, sir. Thank you.
LLP agreement.
Sir, whether stamp duty applies on conversion of properties?
Yeah, stamp duty applies if you are incorporating a limited liability partnership. So respective state jurisdiction will be applicable and you will be required to pay the stamp duty as per local laws. Like in UP, it is 750 rupees. Majority of the places, it is 750 rupees. But depending on different jurisdiction, it may be increasing. I think in Delhi, it is 1,000 rupees, if I'm not wrong.
And with respect to conversion of the immovable properties, sir.
So conversion of immovable property from one
firm to LLP. Yes, sir.
From partnership firm to LLP, as far as law position is concerned, the stamp duty is a disputed subject because to me it is not a conversion. To me it is not a conveyance. It is just a transfer by vesting of property by virtue of following a process of law. So it should not attract, you should be allowed a mutation in the name of new person without attracting a execution of document. Because in this case, you don't execute any sale deed. What you do, you only execute a document for conversion of partnership firm into LLP. You're not required to execute any conveyance deed. That by virtue of that conversion deed itself, your property is getting mutated in name of a new person. So you should not execute any sale deed. If you execute any sale deed, the revenue authority is going to ask a stamp duty also. But if you only wish to get the name of new entity recorded by virtue of certificate of incorporation or registration issued by the registrar, the mutation formality will be completed and you will be allowed to register the same without any payment of stamp duty. Mutation charges payable. Yes, please.
Members, any other questions we can ask the speaker? Sarunaraja sir, can you please give vote of thanks, sir?
Yes, sir.
Yes, please.
Good evening to everyone. On the behalf of Management Committee of Tirupur branch of SIRC, I would like to extend my heartfelt gratitude to our esteemed speaker, CS Amit Gupta ji. And I sincere thank to CPE committee of our branch who funded the event throughout. I would like to thank all of our present here for making the time to with us. Thank you to one and all. Thank you, sir.
Thank you, sir.
Thank you, Mr. Rajan.
Thank you very much, sir.
I'll
Thank you
be
for
sharing.
coming with us.
I'll share my presentation. I saw in the chat box that
Yes,
some
sir.
part of my presentation.
It is
was not
a
visible.
request over by our members.
I'll do that. I'll just share right.
If your slides can be shared, then that will be more helpful, sir. Your slides.
Yeah. That is, sir, is selling. We will be getting that slide, sir.
I will share.
Yeah. Please. Thank you.
Thank you, sir. Thank you.
Thank you, sir. Thank you very
All
much
right.
for accepting
All right.
our invitation, sir. Thank you, sir.
Thank you, sir.
Thank you.